Good day everyone. We are the 7th group and we will be discussing about Title 7 Collective Bargaining and Administration of Agreements. I am Joshua Kathleen C. Ponce and together with my co-members Cristana Amistad, Marlon Desherto, Raven Pakibot, and Brian Gabrielias. So I'll be discussing about Article 261, 262, and 263. Article 261, or the procedure in collective bargaining. To ensure timely and fair negotiations, a procedure must be followed. But let us first define collective bargaining. So collective bargaining means creating and carrying out a binding collective agreement between employers and employees within a company. So there are 5 steps to start negotiating for an agreement. First, one party, either the employer or the employee's representative, will send a written notice with its proposals, and the other party who will be receiving should respond 10 days from receiving the notice. Next, if there are any differences or disagreements, either side may request a conference which must commence within 10 days from the request. And third, if there is still no agreement reached, then the labor board will intervene, either requested or sila mismo. And then both must participate. Fourth, during the process of conciliation, both parties must avoid any action that makadisrupt or delay sa settlement. And lastly, the labor board helps them to resolve their issues in a peaceful and cooperative manner and encourages them to bring issues to a voluntary arbitrator. So, an arbitrator is an independent referee that is mutually chosen by them who gives a final binding verdict. So, binding man ang verdict, which means both parties shall follow. So let's move on to Article 262, the duty to bargain collectively in the absence of collective bargaining agreements. So even without a signed contract, CBA, or any voluntary agreement, both employers and employees representative or unions still bear the responsibility to negotiate. And to do so, they'll have to follow the earlier 5 steps or procedures. But why need gihapon even if walay CBA? Because it is mandated by the law, which is to mainly promote and maintain labor and management relations. Now, Article 263, meaning of duty to bargain collectively. It is the mutual responsibility of both parties to meet and negotiate regularly, on time and no delays, and in good faith, to discuss about wages, the working hours, terms and conditions of employment, and adjustments to any grievances or questions that may arise. And if either of the party requests for a contract, then they must execute a written contract containing their agreement. But either of the parties cannot be legally pressured. Di sila pwedeng i-pressure or i-force to accept terms or proposals that they do not agree, or even just making some adjustments or modifications to their original demands just for both of them to reach an agreement. So here's a case study. It is about the Guagua National Colleges versus the GNC Faculty Labor Union with the General Register number 252101 decided by the Supreme Court on March 5, 2025. So in this case, Guagua National Colleges and its faculty and non-teaching unions negotiated a 5-year CBA back in 2009 na ay mga benefits nga gi-include ani such as rice subsidy, clothing allowance, and longevity pay. And actually, both parties kay ni-agree na sa draft nga CBA. But then, ang GNC kay nagdugay og perma sa final document. And of course, kung wala pa na permahan ang final document, wala sa na-implement ang mga benefits nga ilahang nasabutan. And because of this delay, the unions accused GNC of bad faith bargaining and they filed for notice of strike. And then, the NLRC intervened through compulsory arbitration. Gi-impose nila nga ang draft CBA kay mao ang official agreement, and they issued a writ of execution requiring GNC to pay the benefits from 2009 to 2017. But then again, ang ilahang contract or agreement kay 5 years lang gikan sa 2009, which will end on 2014. So lapas na. Mao na ang GNC kay ni-challenge sila, and they said that ang NLRC doesn't have the authority to enforce the CBA, and the benefits should not be computed beyond the actual effectivity date, which is again 2009 to 2014 lang. So the main issues or questions here are: can the NLRC enforce the economic provisions of a CBA imposed due to unfair labor practice? And did the NLRC overstep by awarding benefits beyond the CBA's valid period? And the court's ruling are: first is yes, the NLRC can enforce the economic provisions of the CBA kung naay unfair labor practice. But no, it was improper and wrong nga gi-compute ang benefits beyond the effectivity period, which is sakto ang giingo sa GNC, and the signing bonus is not enforceable. So, ang case was returned sa NLRC para sa recomputation o sa mga kuwang nga kailangan ihatag sa GNC adto sa mga employees. From June 1, 2009 until May 31, 2014 lang, dili maabot sa 2017. So, that's for my part. Thank you.
Good day everyone, I'm Brel Gabrelius, and today I'll be presenting Duty to Bargain Collectively. I'll walk you through its key roles, stages, and why it plays a crucial role in maintaining fair and productive labor relations. Article 264, Duty to Bargain Collectively when there exists a collective bargaining agreement. Now, what is collective bargaining agreement or CBA? It is a legally binding contract negotiated between an employer and a labor union representing a group of employees. So when CBA is active or in place, primarily for negotiating new agreements when the old one expires, adjusting terms, and handling grievances. But it also extends to negotiating changes during a CBA's term and is a mutual obligation for good faith discussions on wages, hours, and conditions. Though it doesn't force agreements, the core idea is continuous industrial democracy, ensuring both sides are met promptly to discuss employment conditions, preventing unilateral changes, and settling disputes, with violations being potential unfair labor practice. So on our next slide, we have here the 264 article. When there is a collective bargaining agreement, the duty to bargain collectively shall also mean that neither party shall terminate nor modify such agreement during its lifetime. However, either party can serve a written notice to terminate or modify the agreement at least 60 days prior to its expiration date. It shall be the duty for both parties to keep the status quo and to continue to full force in effect the conditions of an existing agreement during the 60-day until a new agreement is reached by the parties. To fully understand the idea on this topic, let's have a little storytelling. So, this one would be a case study of CIPSI versus the MPLO back in 2023 with the Supreme Court ruling number 235569 back on December 13, 2023. What's the issue? So, SCIPSI failed to remit union dues that had already deducted from employees under the CBA check-off clause. So what's the ruling? The Supreme Court ruled that withholding union dues will actually equals to unfair labor practice or ULP because it interferes with the union's right to self-organization and violates obligations under the existing CBA. Now, let's read this case study. So, on this one, I reviewed the 2023 case decision on the Supreme Court involving the South Cotabato Integrated Port Services Incorporated or SCIPSI and Makar Port Labor Organization or MPLO, which highlights that the continuing obligations under the duty to bargain collectively under the labor law, in this case, the MPLO, accused CIPSI with holding union dues collected via check-off provisions in their collective bargaining agreement and failing to remit these dues, effectively interfering the union functions. So here on the next slide, we have the union argued that the non-remittance violated their right to self-organization and constitute to unfair labor practice. The Supreme Court agreed that the withholding of union dues by an employer under CBA's check-off clause is not merely an intra-union dispute but an unfair labor practice. As such, the proper forum is not a mediator-arbiter but labor arbiter. By reclassifying and non-remittance as unfair labor practice, the court affirmed that the employer's duty to bargain continues even under the existing CBA and cannot be evaded by invoking trial or substantive technicalities. The ruling underscores that the duty to bargain collectively does not end with a signed CBA obligations, such as check-off remittance and respect for the union's role remain, failure to comply the liability. For unions and employees, the decision reaffirms that the union financial security and continuity is protected by law. For employers, it serves as a cushion that compliance with all CBA terms remains mandatory. I conclude that this 2023 Supreme Court ruling demonstrates a concrete, enforceable, dimensional of duty to bargain collectively under the existing CBA. Between bargaining per se, down to implementation and union substating mechanisms. And now we are here, the stages of bargaining process. So we have here the stage 1, organization or representational. The first stage focuses on creating and formalizing the union that will represent the employees. In this stage, employees form a union, register it, and request voluntary recognition from the employer. And if voluntary recognition is not given, the union may file a petition for certification election so that workers can vote and decide who will be their exclusive bargaining representative. Part of this stage includes determining the collective bargaining unit or CBU, meaning who exactly belongs in the bargaining group. And then after this, a certification election is held. Once the union wins, they receive the certification of exclusive bargaining representative or EBR. There is also a possible detours or deviations in the stage, such as election protests or appeals to the labor secretary, court cases or strikes due to union busting, and other unfair labor practice. Sometimes third-party intervention like reconciliation, mediation, or arbitration may also be required. So here on the stage 2, we have the bargaining proper, which is a second stage where the actual negotiation happens between the union and the management. So starts with the bargaining preparations followed by the presentation of proposals and counter proposals from both sides, and then the team negotiations on mandatory subjects like wages, hours of works, benefits, and as well as non-mandatory items. Once both sides reach an agreement, the CBA ratified by the employees then signed it. After signing, this is the official registered as a collective bargaining agreement or CBA. However, bargaining may also experience detours such as strike or lockout when there is a deadlock or one-sided commits on unfair labor practice during the negotiation. So again, third-party intervention like conciliation or arbitration may be used to resolve these issues. So last is the stage 3, which is the contract administration. On the last stage is about implementing the CBA and ensuring both parties comply with its terms. Any questions or disputes involving the CBA are processed through the grievance machinery or voluntary arbitration. On the second or third year, the parties may renegotiate economic or non-representational terms. And on the fifth year, there is a freedom period where employees can choose whether to elect a new bargaining representative or keep the existing one. Detours may also happen here as well. A union may strike due to gross violations of economic provisions in the CBA, or if disputes remain unsolved, with third-party conciliation arbitration may be necessary. So here on the next slide, the duty to bargain collectively. To begin, the duty to bargain only arises when there is an employer or employees representatives or labor union. If there is no employer-employee relationship, then there is no duty to bargain. So please take note of that. But if the duty already existed and then one party refused to negotiate, then the refusal is considered as a violation of the law. The law says that the collection of bargaining happens between the employer and the employee represented by their chosen labor union. While both parties may initiate negotiation, the party's employer is not legally required to start the process. However, the employer must respond in good faith once the union demands bargaining. Before the bargaining can begin, certain jurisdictional provisions must also be met. So there are what do you call this one, majority representation of the employees. The union must meet the procedural requirements of presentation set by the labor code, and there must be a formal demand to bargain under Article 261. And under this article, when their conditions are complete and collective bargaining process must begin within the certification year, which means 12 months after the union is certified as the exclusive bargaining agent. So here on the next slide, we have the law recognizes two situations where duty to bargain exists, which is situation 1, when there is no existing CBA, and on the situation 2, which is when the CBA already exists. So on the situation 1, it is cited on the Articles 262, and here in situation 2, it is cited here on the 264. So by this next slide, we have here the law recognizes two situations when there is duty to bargain exist. Situation 1, which is on Article 262, when there is no existing CBA yet. But on situation 2, which is what we are tackling now, Article 264, we have CBA already. That's why it's already existed. So on the first situation, the Article 262, the duty to bargain means that both of the employer and the majority union must meet and negotiate on the following process. To negotiate a CBA on mandatory subjects of bargaining, which includes wages, hours of work, and terms of work or conditions of employment. This also includes proposal or questions that may arise while negotiating. The parties may also execute a contract incorporating their agreements of either party requested. Finally, the kind of compliance is expected that bargaining must be a prompt, expeditious, and done in good faith. It is also important to note that the duty to bargain does not force either party to actually agree to a proposal or to make a concession. It is only requires both parties to meet, negotiate, and sincere attempt to reach an agreement. So here on the next slide, now I will discuss the duty to bargain when collective bargaining agreement is already in place. In this situation, the duty to bargain includes the normal obligations such as meeting negotiations and acting in good faith, but also adds one more important rule that neither party can terminate or modify the CBA during lifetime unless they follow the required legal process. 60 days before the CBA expires, either the employer or the union may send a written notice to renegotiate the agreement. This is also called a freedom period, which is 60 days. During this time, and even after the CBA technically expires, the law requires both parties to maintain status quo. This means that the CBA stays fully in effect until a new agreement is reached. So here on the next slide, we have the violations of this duty to bargain amount to unfair labor practice. These violations include failing to meet, evading the negotiation process, bargaining in good faith, or grossly violating the economic provisions of the existing CBA. Although the law allows the parties to use faster bargaining methods, this cannot be used to avoid their legal obligations to bargain. A well-known example of this, as on the book, is the Kyokloi case. Here, the union was properly certified and submitted its bargaining proposals, but the employer gave no counter-proposal at all. Because of this refusal to bargain, the NLRC imposed a union's draft on CBI and the employer, and the Supreme Court held that ruling. So this case shows that a crucial good faith is, and because of collective bargaining succeeds or fails based on the sincerity and credibility of both parties. So on next slide, I'll be discussing the difference between the good faith and the bad faith shows in our Venn diagram here in the screen. So let's start with the bargaining in good faith. Refers to the sincere effort for both employer and the union to reach a fair and mutually beneficial agreement during negotiations. In good faith bargaining, the parties honestly negotiate as shown as their willingness to compromise. They attend scheduled meetings and provide necessary information. Most importantly, they do not rely on negotiations on purpose. The main goal here is to promote harmonious labor management relations through a valid and fair collective bargaining agreement or CBA. And now let's move on to the bargaining in bad faith. Now, this happens when a party only pretends to negotiate with actions showing that they are not truly cooperating. Examples include unnecessary delays, rejecting proposals without valid reasons, or surface bargaining, or negotiating only for show. Withholding important informations. With these kind of behaviors obstruct the bargaining process and is considered an unfair labor practice or ULP. Centered Venn diagram, we have similarities though, but good faith and bad faith bargaining part of the collective bargaining process as they involve in two main participants, which is the employer and the union itself. However, the distance or the difference lies in their attitude approach toward reaching an agreement. So to sum this up, good faith aims to build cooperation and bad faith destroys the trust and may lead to disputes and legal consequences. So on our next slide, I'll be discussing three concepts related to collective bargaining. We have the deadlock, bulwarism, and also disclosure of information. So first, we have here the deadlock. This happens when both of the employers and the union cannot settle their differences in negotiation. This is no progress, no compromise, and no clear plan to move forward as a result. And this situation may lead to strike or lockout. And next is bulwarism. This occurs when the employer offers a take it or leave it proposal, when this final or open bargaining. The employer not even communicates directly with the workers instead of the union. Since there is no real obligations happening or a real negotiation, this becomes an unfair labor practice and is considered bad faith bargaining. Lastly, we have the disclosure of information. This is the right of an employer representatives to access needed information, especially wages related data, so they can negotiate fairly. If the employer refuses to disclose information, it can again result in bad faith bargaining. And in summary, effective collective bargaining requires sincere negotiations, openness, and respect for each party's rights. So here on the next slide, I'll be discussing three important aspects of collective bargaining agreements. So here on the contents of CBA, modification, and ratification and registration. So first, we have the contents of CBA. A CBA contains a agreed provisions between the employer and unions. These include managerial rights, union recognitions, wages and benefits, working conditions, grievance procedures, and contract durations. It must also include a drug-free workplace policies in compliance with our Republic Act 9165. Second is the modifications of the CBA at least 60 days before the CBA expires. So either the party nor the union may ask to modify or renew the agreement. Changes do not always mean increase in wages or benefits. They may also involve reductions when necessary. What matters is that revisions are done in good faith, and also lastly, ratification and registration. After negotiations, the CBA must be ratified or approved by the majority of all workers in the bargaining unit, not just union members. So it must be posted 5 days in the visible areas to inform employees once ratified, and also it must be registered with DOLE within a 30 days to ensure the validity of this clause. So on the next slide, we move on now to the centralized or decentralized bargaining. In the Philippines, the common type of collective bargaining is decentralized bargaining. This means that the CBA applies only to one particular enterprise and covers only the workers in that company. However, we also have this centralized bargaining, which also allowed when several employees agreed to negotiate together under one CBA. For example, companies located in a special economic zone or a business in one industry such as fast food or hotels may choose to have a common CBA. They may also decide which provisions to be applied commonly and which will be their customized per enterprise. So on the centralized bargaining as introduced under the DOLE Order number 4003 and is entirely optional for both employees and employers and also the unions. The procedures may be modified as long as the objective is to create a more efficient and expeditious bargaining process, which is allowed under the Article 262 of the Labor Code. To conclude, decentralized bargaining is the standard practice in our country, but centralized bargaining offers a flexibility for a group of employees or group of employers who wants a faster unified agreement. So that ends my report, and once again, I'm Brad Gabrelias, here to make the Article 264 simple for you. Thank you.
Good morning, everyone. I am Raven L. Pakibot, and I'm going to discuss the Articles 265 and 266. So first off, let me discuss about the 265, or also known as the term of the Collective Bargaining Agent or CBA. I'm also going to discuss the key rules, timelines, and jurisprudence of this article. Before we begin this topic, I'm going to discuss first what is CBA or the Collective Bargaining Agreement. It is a contract between the employer and employees union that outlines the terms and conditions of employment, including wages, benefits, working conditions, and the rights and responsibilities of both parties. So next is the term of CBA. So in this article, it outlines the essential rules governing the duration, renegotiation, and effectivity of collective bargaining agreements. So first, every CBA contains two timelines: the representation aspect, which refers to the union's majority status that lasts for a fixed term of 5 years. During this period, no union may question the bargaining agent status except during the 60 freedom period before the 5th year ends. Meanwhile, all provisions such as wages, benefits, and working conditions must be renegotiated not later than 3 years after the CBA takes effect. Next is we have the retroactivity of renegotiated provisions. So when it comes to retroactivity, if the employer and the union reach a new agreement within 6 months after the old CBA expires, the new terms automatically retroact to the day following the expiration. And if they reach an agreement beyond 6 months, both parties must determine the start of retroactivity. And for CBAs, they must resolve through arbitration awards. The Secretary of Labor decides the retroactive effect when the parties cannot agree. Next is we have the effectivity of a CBA. So regarding effectivity, dates newly created CBAs may begin on any date mutually chosen by both parties. But renegotiated or extended CBAs must follow the retroactivity rules under the Article 265. Next is we have the automatic renewal rule. So if the parties fail to renew or renegotiate the CBA on time, the law mandates automatic renewal, meaning all existing terms continue to operate until a new agreement is reached. Next is we have the duration of provisions. In terms of duration, the representation aspect is always valid for 5 years, while all other provisions remain effective for up to 3 years and must be renegotiated every cycle. Also, the jurisprudence recognizes that CBAs can be flexible when justified by exceptional circumstances and agreed upon by both parties. A notable example is the Philippine Airlines case, where the Supreme Court upheld a 10-year suspension of the CBA due to extraordinary business conditions. So this flexibility demonstrates that while the Article 265 provides structure and protection, it also allows room for mutually agreed solution tailored to unique situations. Okay, now is I'm going to discuss the case that I can relate to this Article 265. We have the Philippine Bank of Communication Employees Association versus the Philippine Bank of Communications. It was actually a case from February 14, 2022. So in this case, PBCom and its employees union had an existing CBA that includes certain benefits such as a loan program where employees could use their bonuses as collateral and a service award policy. When new management took over, they changed benefits on their own without consulting the union. This led to the issue: can employer change benefits that are already part of the CBA without renegotiation? Supreme Court said no, and the court ruled that these benefits form part of CBA because a CBA is considered the law between the parties. So neither side can unilaterally change its terms, and the employer must negotiate with the union and follow the renegotiation timelines under Article 265. The court also added that CBA benefits remain binding for their full duration, with 5 years for the representation aspect and 3 years of all other provisions. If the benefits have been consistently granted over time, they become CBA obligations. Even if originally introduced as company policies, the Supreme Court sided with the union, so the PBCOM's unilateral changes were invalid. The contested benefits had been consistently granted through past CBAs and communications, proving they were negotiated benefits, not mere company policies. So it allows the PBCOM to modify CBA terms on its own would undermine collective bargaining and violate the labor law. In relation to the Article 265, this case reinforces that CBA provisions cannot be changed at any time. They remain in force until properly renegotiated, protecting employees' rights and ensuring the stability of labor management relations. Next is we have the Article 266, or the injunction prohibited. So its general rule is that no injunction in labor disputes. The courts may issue a temporary or permanent injunctions in labor disputes, and it reflects the government's non-injunction policy to let parties resolve disputes on their own. It supports the primacy of collective bargaining and voluntary dispute settlement, and the government intervention must remain the exception, not the norm. And its purpose is to prevent unnecessary government interference in labor management conflicts and to promote the primacy of collective bargaining, peaceful negotiation, and voluntary dispute settlement. What is an injunction? So an injunction is a court order where requiring someone to do something or to stop doing something. It may be a mandatory, meaning you must perform an act, or prohibitory, meaning you must stop an act. Even though the injunctions are generally not allowed, there are limited exceptions. Under the Article 279, a court may issue an injunction only if there are illegal acts during a strike or lockout. Like, for example, blocking the factory gate or committing violence. The injunction is directed at the illegal act, not the strike itself. It must also follow strict procedures such as hearings and evidence. Lastly is the national interest cases. So the Secretary of Labor can step in and immediately issue an injunction even without a request. This can stop the strike itself if the industry is vital to the country, such as power, transportation, or healthcare. So in summary of this article, it protects the right to strike and promotes negotiation, but still allows injunction in cases of illegal acts or when required for the national interest. I'm going to discuss a case that can relate to this article, which is the Manggagawa sa Komunikasyon ng Pilipinas versus PLDT Incorporated and PLDT Incorporated versus Secretary of Labor and Employment. So, this case centers on disputes between PLDT, its contractors, and affected workers regarding contract agreements, regularization, and labor standard issues. Because the controversy had widespread impact and involved essential telecommunication services, the Department of Labor and Employment took action through its enforcement and visitorial powers. So this is where the injunctions comes in. So normally, in Article 266 prohibits the issuance of injunctions in labor disputes, protecting workers' right to strike, picket, and peacefully protest. However, the court clarified that when the Secretary of Labor assumes jurisdiction because a dispute affects national interest, strikes and lockouts may be automatically enjoined. So this creates a lawful exception to the general no injunction rule. Essentially, the Secretary's assumption of jurisdiction order functions as an immediate and legally binding injunction in itself. So in this case, the Supreme Court remanded certain factual issues to the Dole Regional Office and also reminded employers that they cannot unilaterally alter employment conditions without complying with legal procedures. So in this case, how does this case relate to the article? So it is directly connected since It illustrates that while injunctions are normally not allowed in labor disputes, an exemption arises when the Secretary of Labor assumes jurisdiction over a national interest case. In such situations, the assumption of jurisdiction order operates as a valid injunction, allowing the government to temporarily restrict strikes or lockouts to protect also the essential services. Next is we have the Article 271, or also known as the Article 258A. It sets an important rule in certification elections that the employer is merely a bystander. This means that whether a petition for certification election is filed by a union or even by the employer itself, the employer is not considered a party and therefore has no right to oppose the petition. The employer's role is strictly limited to two things. First is being informed or notified that a petition has been filed, and second is submitting the list of employees during the pre-election conference if the med arbiter decides to proceed with the petition. This rule protects the integrity of certification election by ensuring that the process remains free from employer interference and allowing the workers to independently choose their bargaining representative. So that's it for my part. Thank you so much.
My name is Kristana Ninyamistad and I'm the next reporter. So before we go further, let us now go through Article 267, 255, exclusive bargaining representation and workers' participation in policy and decision making. So it states here that Article 267, at the labor union chosen by the majority of employees in a bargaining unit becomes the sole representative of all employees in that unit for collective bargaining. Even so, individual employees or group of employees may still bring their own grievances directly to the employer at any time. The law also gives workers the right to take part in workplace policy and decision-making processes, especially on matters that directly affect their rights, benefits, and welfare. To support this, employers and employees may create labor management councils whose workers' representative must be elected by at least a majority of all employees in that establishments. To explain further, in Article 267 provides that once the majority again of employees select a labor organization, that union becomes the exclusive representative for collective bargaining. Despite this, individual employees' right to present grievances directly to the employer at any time. So the article also reinforces employees' right to participate in workplace policy and decision making, particularly on matters affecting their rights and welfare. So to support this, establishment may create labor management councils whose workers' representatives must be elected by at least a majority of all employees. So for example, if 100 employees chosen Union A as their majority representative, Union A negotiates the CBA. However, any employees may still independently report issues as unpaid benefits. So next, let us go to our next slide. What a CBU really is. So, as stated in the PowerPoint presentation, a collective bargaining unit is the group of employees who negotiate with the employer as one body, and it is different from the union that formally represents them. The CBU consists of workers who share common or mutual interests, such as similar job functions or work locations. This group must then organize and register to form a union. And while small units may form only one union, larger units may form several, though only one union can become the official bargaining representative. So we have there the example. So to elaborate further, CBU, so again, it is a bargaining unit, refers to the group of employees who negotiate collectively with the employer, while the union is the formal organization that represents that unit. So these two concepts must not be confused. A bargaining unit is considered appropriate when its members share mutual interests. So, Again, bargaining unit is considered appropriate when its members shares mutual interests, such as similar work, job conditions, or geographic locations. So it ensures effective and unified representation. So for example, in a school, teachers may form one bargaining unit while non-teaching staff may form another. In a factory, production workers may form one unit and sales employees another due to differing job interests. So next slide. Let us go through one employer, one unit, and let us read the details in my slides. So the law generally prefers that all rank and file employees is one company form a single bargaining unit, separate from supervisors. So this is because keeping employees united strengthens their bargaining power and avoids weakening the group by dividing it into smaller units. As a rule, one plant or enterprise is presumed to be an appropriate single bargaining unit for collective bargaining purposes. However, this principle applies only within the same employer. Even if two companies are related or connected, they cannot be combined into one bargaining unit because each corporation is considered a separate employer. So despite having two companies or related or being connected, they cannot be combined into one bargaining unit because each corporation is considered a separate employer. So to shorten or to summarize, the law again generally favors a single bargaining unit for all rank and file employers within an enterprise. So that is one employer, one unit. It is also a basic principle that two separate corporations cannot be treated as one bargaining unit even if they are related or affiliated. So, for example, all rank and file employees of Company X from one unit, but Company X and Company Y, those sister companies, must each other have separate bargaining units. So, for example, given the situation, ABC Corporation and BBC Corporation, they are sister companies, but their employees, or employer rather, are different, so they cannot become one bargaining unit. Next slide. Let us go to EBR, the bargaining representatives. So let us read the slides at my back. The exclusive bargaining representative is the union chosen by the members of the bargaining unit to represent them in negotiations with the employer. Although there may be several unions within one bargaining unit, only one can serve as the official representative, and this is decided through an election among all CBU members. So this is decided through an election by all the collective bargaining unit members. It is important to distinguish the bargaining unit from the union. So the union is a group of employees being presented, while the union is the organization representing them. This distinction also affects voting while negotiating or approving a collective bargaining agreement, CBA. All employees in the bargaining unit, not just union members, have the right to vote. However, when deciding whether to hold a strike, only union members are allowed to vote, not the entire unit. So, in other words, in cases where multiple unions exist within one bargaining unit, only one union may serve as the exclusive bargaining representative, or EBR. This representative is chosen through an election among employees in the unit. It is also important to distinguish voting rights. 1. For CBA approval or rejection, all employees in the unit vote. 2. For decisions such as calling a strike, only one union members vote, as what I have discussed earlier, and it is there at my side. So for example, if 3 unions complete within a bargaining unit, employees select one union to serve as the EBR, or the exclusive bargaining representative. Next slide, we have the employees' right to participate. All employees, whether unionized or not, have the right to participate in workplace policy and decision-making through organized channels, such as the councils. This participation allows them to express opinions and make suggestions, but it does not give them management powers or the authority to approve or reject decisions. The law and the constitutions guarantee this right, emphasizing that employee participation, not just collective bargaining, is a core part of industrial democracy. So, to elaborate further, employees, whether unionized or not, have the right to participate in policy and decision-making processes within the workplace through organized mechanisms such as councils. So this right is guaranteed by the Constitution and emphasizes in labor laws. However, this participatory right does not grant employees management authority. They may express recommendations and opinions, but they cannot approve or veto company decisions. For example, employees may participate in discussions regarding workplace safety rules but cannot determine management, budgets, or operation policies. So that is employees' right to participate. So next slide, we have our LMC, which is Labor Management Council. So let us read the slide. Employees, whether unionized or not, have the legal rights to present grievances to their employer at any time, with or without collective bargaining. To support participation, the law allows but does not require the creation of Labor Management Councils or LMC or committees. LMCs provide a formal forum for employees and management to discuss concerns, resolve disputes, and address grievances. They serve mainly as a communication and problem-solving mechanism, prompting employee involvement in workplace issues even outside the scope and collective bargaining. So the law also recognizes the right of employees to raise grievances at any time, regardless of union membership. To enhance communication, establishments may form labor management union or committees, which serve as venue for dialogues, problem resolution, and early dispute prevention. So for example, an LMS may regularly convene to address concerns such as scheduling issues or workplace hazards, even outside the context of collective bargaining. So let us now go through Article 267-256, representation issue in organized establishments. Let us read the context in the slides. In organized workplaces, if a labor organization questions the majority status of the current bargaining agent, it can file a verified petition with the Department of Labor and Employment within 60 days before the collective bargaining agreement expires. If at least 25% of employees in the bargaining unit support the petition, a secret ballot election is automatically ordered. For the election to be valid, a majority of eligible voters must participate, and the union receiving the most votes becomes the exclusive bargaining representative. If there are 3 or more unions and no clear majority, a runoff election is held between the top 2 unions, provided that at least 50% of total votes were cast for the contending unions. If not, petition is filed after the agreement expires. The employer continues to recognize the incumbent union as the majority representative. So again, under Article 268, employees may challenge the majority status of the existing bargaining representative during the 60 days freedom period before the CBA expires. If a petition is supported by at least 25% of employees in the unit, the med arbiter orders a secret ballot election. A valid election requires participation from a majority of eligible voters. The union receiving the most voters becomes the exclusive bargaining representative. If no union obtains a majority in an election with 3 or more choices, a runoff election is conducted between the top two unions. If no petition is filed during the freedom period, the employer continues recognizing the incumbent bargaining representative. So for example, if 25% of employees signs a petition questioning the current union on election, must be held to determine which union has the majority support. And that ends the part of my report. Again, this is Kristana Ninyamistad. Thank you.
Good day to each and everyone. So, I am Marlene Annabel V. Desharto, and I am assigned to tackle all about Article 269 and Article 272 of Title 7, Collective Bargaining and Administration of Agreement. So, for today's discussion, let's talk first about Article 269, which is all about petitions in an organized establishment. So, under this article, we have here the voluntary recognition, certification election, where and when this certification election may happen, the petitions, certification election, or the PCE in organized company, and how we have consent election instead of certification election, the election bars, the questioning of union legitimacy, question of existence of employer-employee relationship, all about the voters under this election, and then required votes or the rematch under this certification election, and then the failure of election, what might happen if the election fails, and then certification election different from union election. So we're gonna differentiate the two of them. So let's talk first all about voluntary recognition. So voluntary recognition happens when a union is recognized without an election in a workplace being unionized in the first time, and where only one union exists. So for the term is from the term itself, voluntary. So for example, there's only one union in a certain company, and then such union could volunteer themselves to become the bargaining agent, and only the employer may be able to assist or kanang sila raang makapili sa kana nga bargaining agent. Only those employer may approve such bargaining agent of a union. So next is the certification election, which is far different from voluntary recognition, because as we all know, certification election determines who will be the sole and executive bargaining agent in an organized establishment. If there particularly if there is more than one legitimate labor organization. So if ang voluntary recognition kay they can volunteer, especially if isa ra sila ka union sa kanang company, ang kaning certification election is a process that must be done, especially if under one company there are several groups or unions. So sa kana siya kay they will have election with regards to who will be the SEBA, the sole exclusive bargaining agent in a labor union. So next is where and when certification election may happen. So certification election is held in the company premises or a venue agreed upon by the parties. So and its timing is subject to specific rules under the labor code. Actually there could be when a certification election might happen, especially if there are petitions, is in a non-unionized company. So if dili unionized ang kana siya nga certain company, kay they may only be able to have a petition or redo the certification election except for the 12 months. So 12 months after nahitabo ang first nga certification election. Meanwhile, in an organized company, they may be able to have the petition only after the freedom period. Okay, so next is that we're gonna talk all about the PCE, or the petition for certification election in organized companies. So a PCE in an organized workplace is filed by a challenger union to replace the incumbent union. So this happens when some of the groups are not satisfied or does not agree with the chosen SEBA, with the chosen sole executive bargaining agent. And then next is the consent election instead of certification election. So a consent election is a voluntary union agreed vote to determine the majority union. So this happens if after doing a certification election, it's like there could be no union, or there could be two union nga kana bitaw murag nagka-same or duol ang ilahang mga voting. So in this case, they must be have the consent, or they can only do this election if all the unions agree nga kanang they will redo this election together with the consent of the certain union. So next is the election bar. So besides a 25% support and observing the freedom period, the petitioner union must avoid three negative requisites that can block a certification election. So when we say election bars, this could talk about the things that you must consider in to be able to have an election. So under these election bars, let's talk about three certain things that you must avoid in order for you to have a free, or to have a good or smooth running of election. So first is the certification year bar, deadlock bar, and then contract bar. So let's talk about the election bar. So the three requisites or negative requisites that we must avoid. So first is the certification year bar. So no certification election may be held within 12 months from a previous certification election. Meanwhile, deadlock bar, it is when no certification election may be held if there is a pending bargaining deadlock which has been submitted to the arbitration or has become the subject of valid notice of strike or lockout. The next is the contract bar, which refers to the existence of a CBA, or the Constitution of Bylaws, where there is an existing CBA which has been duly registered, or a petition for certification election is filed. Okay, so that's the difference of the three. So now we will proceed about the question of union legitimacy. So questioning a union's legitimacy does not suspend a petition for a certification election. Question of existence of employer-employee relationship. So questions about employer-employee relationship does not dismiss a PCE. So union legitimacy. So if the legitimacy of the union that filed a PCE is questioned in a petition to cancel its registration, such question does not suspend hearing the petition for certification election. So wala na siya epekto, dili siya ma-cancel, or dili pwede just because kanang nag-question ka if legit ba jud na siya ang kanang union. And then moreover, ang kanang existence of employer-employee relationship, they cannot dismiss such PCE because all issues pertaining to the existence of employer-employee relationship, or the eligibility of members, or commingling in union membership shall be resolved in the decision granting or denying the petition for certification election. So they cannot affect unless if kanang they cannot affect, but if such cases or issues may evolve, they can have it resolved under a third party. So next is that we're gonna talk all about the voters. So all employees in bargaining unit at the time of the order, including contested, dismissed employees, are eligible to vote. So when we say voters, all voters are bisan pa og it's like even if employees are already dismissed, but for as long as they are part of that certain union, they can still be the considered voters of that election. And then next is the required vote, or the rematch. So majority of qualified voters, 50% plus 1 must vote, and winner is determined by majority of valid votes cast, not total votes or total voters. So it does not mean nga kanang magdepende siya sa kanang totality sa kung pila ang nagbotar, but ang kanang considered nga valid vote. So what we considered valid vote is the 50% plus 1. So, dili siya pwede nga magduo lang sa equal. It must be like half and then plus 1. So, mula pa siya sa katunga. Next is the failure of election. So, the 12-month bar applies only if an actual election occurred and the same voter list and guidelines are used and notice must be posted 10 days prior. So, when we say failure of election, so, if example, what you have done is certification of election. So, if such election may fail, they can only consider it as failure of election, and then the next election may only be done 12 months after the said certification election. And then next is the certification election, different from union election. So, we already know all about certification election. It's like selecting the SEBA, the sole executive bargaining agent. So, when we say union election, it selects the officers of the union. Certification election selects the particular union that will represent the bargaining unit in bargaining with the employer. So, their main difference is that certification election chooses the certain or one union that will represent the whole to bargain with the employer. Meanwhile, ang kanilang union election is all about selecting the officer. So, next is I have here a case study. So, it is all about Holy Child Catholic School, and the petitioner is Holy Child Catholic School is the petitioner versus Honorable Patricia Santo Tomas in her official capacity as Secretary of the Department of Labor and Employment, and pinag-isang tinig at lakas ng anak pawis, Holy Child Catholic School Teachers and Employees Labor Union. So, respondents. Mano siyang respondent. So, ang company is the Holy Child Catholic School, a private educational institution. Meanwhile, the petitioning union is the pinag-isang tinig at lakas ng anak pawis, Holy Child Catholic School Teachers and Employees Labor Union. So, it is a case study about Article 269, which is the petitions of in an organized establishment. So, the date of petition is May 31, 2002, and verdict or answers from the court is given July 23, 2013. So, the allegations in this case study is that HCCS is a private educational institution. So, the proposed bargaining unit consists of approximately 120 teachers and employees. So, the company is unorganized, meaning there was no existing collective bargaining agreement or a previously certified bargaining agent for the proposed unit. So, an action that they want is that the petition was filed to request a certification election. So, we already see how important certification election is. It is for them to actually, ang importance ng good sa certification election is that it allows you to have your mutual, or for example, if you have something that you want to voice out or raise to your employers, then you can have a representative that will talk to the employer. So, legal basis is that based on Article 257 of the Labor Code, a med arbiter is mandated to automatically conduct a certification election upon the filing of a petition by a legitimate labor organization in an unorganized establishment. So, what is the key principle or the things that we can get from this case study is that the importance of certification election. So, they were fighting for the right to be considered or to be recognized as the bargaining agent in that Catholic school. So, that would be from the case study. So, let's now talk about the Article 272, Appeal from Certification Election Order. So, order to hold certification election in an unorganized establishment is not appealable. So, issues are raised via protest on the election conduct or results. Orders or decisions granting, dismissing, or denying a petition in organized or unorganized establishments can be appealed to the office of the secretary within 10 days. So, we already know na once a certification of election will happen, you cannot interfere or kanang kanang murag patunga on that certain day wherein nga happening ang certification election. You cannot interfere or have a petition on that same day wherein certification election is happening. The only thing you can do if you want to file for a petition or you do not agree to that certain union is that for you to wait for the results and have a protest or have your petition filed only after the election have their results. So that is the keynotes or the highlights of Article 272. It is all about how you can appeal or file for a petition only and only after the certification election has its results. So that would be all for my part. Thank you.